And that will confirm that proper service was made on the actual individual. Now, what if someone did not know that there was a restraining order? How does that affect that individual?
Well, it would come up if there was an alleged violation, of course, notice. And it doesn't have to technically be served either in hand or by mail if the person has notice, either by phone or by some other mechanism. You know, they can be held to have sufficient notice, and obviously they would have to adhere to the terms and conditions of the restraining order.
No, that's a call the court would make. So he had notice. He had to be here, or he had to respond. In the case with my client, they left. No, the local police came over and served them in hand.
They did. So, you know, we see about Massachusetts issues about 25 to 50,000 restraining orders a year, just in Massachusetts. You mentioned that some of the orders are a tool to affect children in custody cases. Can you explain a little bit more about that? How one benefits and how the children benefit from a restraining order being, you know, say you can't see your father for a couple of days, you can't see your mother for a particular amount of time. What type of effects does that do to the children?
I think, if I may, that what I was trying to say was, you have a situation where the parties are split up, they're going to get divorced. An unscrupulous mother, if she feels there's going to be a custody battle, can create enough emotion to walk in and get a restraining order under 209A.
Which is totally different from the harassment prevention orders, correct?
Well, some of the tests are the same.
Okay.
I mean,
But you don't need the 3 times.
You don't need the 3 times.
You could have a single
right.
incident, and you know, you can get your restraining order, get the other parent out of the house.
Move the party out of the house. And
So once the court issues that order, now they move the party that the accusation was made against. They remove automatically from the house. I've read that they have to surrender their firearms if they are a licensed firearm carrier.
Yeah.
Doesn't that violate someone's due process and the right to equal protection, the right to face their accuser in a court before these actual orders are issued?
Well, if they're issued ex parte, because most of the restraining orders are issued ex parte. The one party will go in, they'll apply for a restraining order, and the other person isn't there. Although sometimes, like in, you know, especially if there's a pending criminal case, the other party may be there, and then you will have you could have the hearing right then. So, and there's also provision though. If you are ordered to surrender your ammunition and your guns and any other weapons you have, you can go into court to try to get it back, especially if you're, you know, there's been police officers that I've seen that have had restraining orders issued against them, security guards, people that need their weapons to be able to, you know, have their job. So that you get that at the so-called 10-day hearing.
So we do actually see a whole bunch of abuse in restraining orders. Have you guys seen the restraining orders being abused?
Oh, sure.
Absolutely.
In the system. What do you think needs to be changed in the restraining order aspect so people are held more accountable versus, because I know there's perjury charges if you can prove that someone has committed or obtained a restraining order fraudulently, because these restraining orders are signed under the pains and penalties of perjury.
And everything in the district.
I've never seen a perjury on something like this. I don't know if you have, counsel.
So if it's proven, you're saying that because it's signed under the pains and penalties of perjury, and I'm assuming that perjury in the state of Massachusetts carry maybe a 20-year sentence for perjury. I could be wrong, but
I think it's only 5. But I've never seen anyone prosecuted for you know, lying on a restraining order.
No.
And sometimes it's pretty blatant. But I think the problem, Hector, is, you know, and obviously, you know, in a large, probably even a large amount of cases, the restraining orders are necessary to prevent abuse. But there is a number out there that, as you say, you know, gained fraudulently. I think the judicial has to look more closely to these instead of giving them out like candy. I mean, you can't just read the affidavit and give it and come back in a 10-day hearing and, you know, automatically extend them. I think, you know, if it's going to be a contested restraining order, you know, both parties are going to have a right to be heard, presented defenses, because the ramifications to these restraining orders are severe.
Yeah, I noticed that in looking at one of those restraining orders today, I noticed that there is a checkbox on one of those restraining order forms in the 209A section that allows an individual person to say, I want my children not to have any contact with that defendant. I mean, you know, should that be removed? Maybe that will stop some of the abuse as far as using children as a tool?
Well, the problem is if the children are going to continue to reside with the person who sought the protection, how can the, let's just say the husband is ordered out of the home. How can he come back and have a meaningful relationship in the home with his children? So in those types of cases, I think your best bet is to go to the probate and family court, where they're more specialized, I guess, in dealing with these types of issues, rather than the district court that, you know, really doesn't want to get involved in custody and support issues.
Now, you mentioned the legislative, the judiciary branch of government. So the judiciary branch is the power that creates these laws at the State House?
Well, no, that would be the legislature.
Okay.
And I think, you know, the intent, the legislative intent on, you know, the harassment and even the restraining orders is great, but it's when, you know, you get into the practice and people use it to their advantage.
So they'll use it to gain custody, advantage in custody. They'll also try to use it to gain public housing, public assistance type of deal, and so on. So basically, there could be a chance that these restraining orders are actually costing taxpayers a lot more money than they're actually helping individuals, would you say?
It'd be hard to give an opinion without seeing the monetary effects. I mean, let me be a bit redundant. I think when you do come in on a restraining order in the district court, you should see the same judge who originally issued it, thereby not putting a pressure on a second judge to reverse the first judge's order. The other thing, I know I'm being redundant, but specificity as to when it happened, where it happened, what time it happened. I think a judge has got to say that, not say, oh, it happened to me 6 or 7 times back in 2005 and once in 2007 without, I mean, it's just unfair.
So under the harassment prevention order, if it takes 3 claims of an act, how does one prove those acts? Who's in a civil restraining order, anyone can go in to get a restraining order. I'm assuming that harassment would have to be issued through the police department?
No. Well, 2 ways. Again, if it's after court hours, you go to the police station, and then you're connected to the judge who's on call. And they do it over the phone. So even though you're at the police station, you are talking to a judge. Or you go into court and during normal business hours and you fill out the application.
Should there be a little bit more training as far as judges are concerned? I like to see if the restraining order is a civil matter and the criminal section has the criminal court, I think there's like 7 different branches within in the State House. Wouldn't it be feasible to, because it's a civil order that holds criminal implication, wouldn't it be better to take it away from the civil side of the court system and keep it all in the judiciary branch and the criminal side of it?
That's a hard question to answer. What I'm thinking is that you're going to go, let's say it's going to be a woman, is going to go in ex parte in front of a judge, having made an affidavit, and is going to make a statement. And the preponderance of the evidence is what you're looking at there. In criminal, you're saying beyond a reasonable doubt. And supposedly that gives you a protection on a violation. But as far as, again, the court being constrained to err to the conservative it's going to continue to do that. And I don't think, you're not going to train judges. I mean, every judge has got his style and his manner and his philosophies. But I mean, you can't do that and train judges. Point being, you can ask, give us more specificity to determine whether or not this really took place, or give the defendant a chance to at least know when.
Or enforce the laws that you were sworn to uphold, basically. Because the Constitution states one thing, and then the laws, they have to follow both. And if they're issuing these orders and denying due process and equal protection and affecting children and family and so on. My understanding on these restraining orders, once these restraining orders are issued, and you can correct me if I'm right or wrong, they go into a database system.
Oh, yeah.
Now, once it's in that database system, does it ever come off that database system?
It can be withdrawn.
But I think it would still
could be
stay
vacated.
be there.
What about expungement?
There is a process to expunge. It's done not very often, though. I mean, you need a very valid reason that this whole, I guess, process was fabricated, something along those lines. Short of that, you know, you're going to be in the database system, and
so you will be in the database, and that will affect employment. It will affect.
It can certainly affect employment. Especially, I know, you know, police officers who have restraining orders issued against them. They're put on administrative duty. So their weapons are taken unless they're able to convince the judge that, you know, they need their weapons back. So it creates a hardship for a lot of people. And the children, too.
And this is part one of a series of part two on the harassment prevention order and the abuse prevention order. We're running out of time on the first part one. Mr. Mixon, why don't you give us a minute or so of your information, so how people can reach you and get a hold of you if they need some legal advice?
My law office is located at 630 Boston Road in the town of Billerica. My phone number is 978-667-2300. And I practice a lot in the district and juvenile courts, where I think a lot of this new harassment statute is going to take place.
And Mr. Wright, would you mind giving out your contact information for those
Yes,
viewers?
my name is Stephen White, spelled S-T-E-P-H-E-N, W-I-G-H-T. My law offices are at 130 Parker Street in Lawrence. That's right on Route 114 in South Lawrence. My phone number is 978-685-2400. I'm licensed in both Massachusetts and New Hampshire. We do a lot of marital along with civil, along with criminal, and essentially that's it.
Well, and I appreciate that. And you have been watching Behind the Scenes. I am your host, Hector Montalvo. Join us next week for part two as we bring you more of the tough questions and you decide.